as a candidate, I had a social media page, a Facebook page for my candidacy, and I did have to block multiple persons from the Facebook page due to statements that were made on the Facebook page, and I do have to disclose that multiple persons by the name of T. Matthew Phillips, letter T. Matthew, next word Phillips, was blocked. Now, counsel, I'm going to have, sir, you've called this court persnickety not once but twice,
Yes.
and I'm going to take issue with that because I mind you that you calling the court language can be actually construed as contempt of court if you're standing before this court and you're calling me names. And that plaintiff and her counsel have had to defend against respondents' arguments which are frivolous, unnecessary, and unwarranted. The court further finds that these claims were brought or maintained without reasonable grounds or to harass the petitioner, who is the prevailing party in both these motions. Specifically, Exhibit 4, in an email from Respondent Phillips to Petitioner's Counsel dated August 25, 2021, Mr. Phillips says to counsel, I have a new lawsuit for you. Will you accept service of process? Or maybe we should make this as expensive as possible. A vexatious litigant is defined as one who repeatedly files frivolous lawsuits. In order to deter such conduct, the Nevada Supreme Court has allowed for the court to limit such vexatious litigants' right of access to the court.
We're on the record, Your Honor.
Okay, we're on the Phillips matter, case number D18. D. This is a sealed matter. May I have appearances, please?
Good morning, Your Honor. Shannon Wilson, bar number 9933, appearing in a pro bono capacity on behalf of now known as.
Thank you. Good morning. Good morning,
Good
sir.
morning.
Good morning, Your Honor. May it please the court, initial T period Matthew Phillips, California State Bar number 165833. I am not licensed in this state.
Okay, you're not licensed in the state, so you're appearing in pro per. You're not an attorney in this courtroom then.
That is correct.
Okay, thank you, sir. Okay, this matter is sealed, so I only have the parties present for this matter. Because I do have a pro per, Mr. Phillips, I'd like to swear you in, and in the event I have questions of me, can I swear her in as well? Please raise your right hands. Please stand and raise your right hand, sir.
I'm sorry.
Thank you, sir.
You and each of you do solemnly swear. Ma'am, raise your right hand, please. You and each of you do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, sir.
Yes, ma'am.
Thank you.
you.
Thank
Yes,
you, sir.
ma'am.
You may be seated.
Thank you.
Okay, we are on for several motions. I have prepared for this matter. I have several motions in front of me, and I am prepared to rule today. However, in the interest of full disclosure, I must make a disclosure to the parties. As a judicial officer, having been sworn in to preside over this matter, I must disclose pursuant to Canon 2.11A and C of the Nevada Code of Judicial Conduct, to avoid the appearance of any impartiality. The court hereby discloses that when I was campaigning as a judicial officer in 2022 as a candidate, I had a social media page, a Facebook page for my candidacy, and I did have to block multiple persons from the Facebook page due to statements that were made on the Facebook page, and I do have to disclose that multiple persons by the name of T. Matthew Phillips, letter T. Matthew, next word Phillips, was blocked. Another person by the name of Matthew, Matthew, T. Phillips, was also blocked. There were 3 persons by this name. I don't know if that is the respondent or the defendant who is here today. However, in the interest of full disclosure, I do have to disclose that these persons were blocked from my Facebook page, both the personal as well as my campaign page. I did not have any communication with these persons, nor did I have any contact with the persons. However, because I do take the judicial canons very seriously, and this was just brought to my attention as I was looking at the page just yesterday, I do note that there was no communication made between this judicial officer and any persons by the name of T. Matthew Phillips or Matthew T. Phillips on Facebook. I do not know if that person or persons are the same person as the respondent, Mr. Phillips, who's here present with me. However, in the interest of full disclosure and to avoid the appearance of impropriety, I do make these disclosures pursuant to Rule 2.11C. I disclose these facts on the record in the event either of the parties believe that my impartiality might be reasonably questioned. I will defer to the parties. I can assure you right now that this will not impact my decision. I am prepared to render a full, impartial, and fair decision by close application of the law to the facts. I have reviewed this case and I am prepared to rule today. However, your trust in me being able to render your decision is very important to me. And so at this point, pursuant to Rule 2.11C, the court is going to ask the parties and their lawyers to go ahead and consider, outside the presence of the judge and court staff, whether or not you would like to waive disqualification, or whether or not you would like me to recuse, or whether you'd like to file a motion to disqualify. At this point, I shall defer respectfully to the parties.
May I ask a question?
Please go ahead and stand, sir, absolutely.
I'm just curious, what did these, I go by the name initial T period Matthew Phillips only. I was just curious, what did these folks ask you that warranted them being blocked?
Sir, I don't recall anymore. This was in 2022. I just know that there were several people that had to be blocked from the page, and names by the name of the monikers Matthew T. Phillips and T. Matthew Phillips were blocked. But I did not have any communication with the people, so at this point I stand ready to rule on this matter. But of course, because I noticed that your name is very similar, I don't know if that was you, sir, or not, but because your name is very similar, I want to make sure that I am fully disclosing to both parties on the record.
Well, thank you very much. I appreciate it.
You're welcome. Would you, if you'd like, would you like me to step out of the room where you can confer and make a decision?
I'm sorry.
It's
I'm
okay.
happy to have Your Honor to rule on the matters.
Okay,
I don't see any need for disqualification.
okay, sir.
I had actually, what I was hoping to do, without going too far into the merits, is I was hoping to have the court issue a temporary order where I can actually be with the minor child and pick him up from school on Fridays and return him on Monday morning. I have a little 2-minute speech I prepared,
Okay.
but this is pursuant to the Roe case.
Okay,
As Your Honor knows, the Roe decision that Carson City recently articulated, it sets new parameters and it defines what is primary
well,
custody.
before I go into argument, because I
Okay.
don't want to overstep my bounds,
Okay, yes.
I want to first make sure that there is no concerns about impropriety before I can even rule on anything. So I'm receiving your testimony on the record, and sir, do you have any concerns about me serving as your judge today?
I have
on this
no
matter?
concerns, Your Honor. I'm happy to have you rule.
Okay, thank you very much, sir. Ms. Wilson, if you'd like me to step out so you can confer with your client, I'm happy to do that. Or if you guys are ready to make a decision, I completely defer. Your trust and confidence in me being able to render a fair, impartial decision is very important to me.
Neither my client nor I have any concerns about your impartiality, Your Honor. You may proceed.
Okay, thank you. So we'll let the record reflect that both parties herein have indicated there's no concerns regarding this court serving as the judicial officer, and therefore both any appearance of impropriety is hereby waived. Is that correct? I don't
Yes.
ever want to put words in your mouth.
Any appearance is waived. I would like to say one thing though.
Absolutely, sir.
And I don't mean to be awkward, but I noticed there's 2 uniformed officers with firearms that are standing. Am I a risk of some kind? I feel like it's almost a criminal courthouse where.
Not a criminal courthouse, it's a family court.
Okay.
We always ensure the safety and protection and of all of our litigants.
I just wish to
So-
say that I have no criminal record of any kind
Excellent.
whatsoever. I've never been arrested or
Thank you.
charged or indicted with anything. And
Okay,
in fact, I like to brag about this. I'm also licensed in the United States Supreme Court, and I just want the
Excellent.
court to know I'm not any kind of risk of any kind. So.
thank you very much, sir. I
Thank you,
appreciate
Your
it.
Honor.
Okay, so there being no concerns by both parties, this court is prepared to move forward to be the judge who's prepared to render a fair, impartial decision based upon the laws, on the facts of this case. I have reviewed everything in this matter, so I am prepared to take everything piece by piece. Do you recognize this is not a trial, this is a motion hearing? And so I've set aside the time for this case. I have actually cleared the rest of today's calendar for the 10 o'clock session for this matter because we have five matters on here. So before we proceed, I'm going to go ahead and render a couple preliminary notices that this court has recognized. But before I do so, let me ask first and foremost, has anything been resolved between counsel and Mr. Phillips? I don't need argument.
There are no
right now, I just
changes.
want to know about resolution. Anything?
There are no changes in the case status, Your
Okay.
Honor.
Thank
And
you.
just very briefly, I tried to send several proposals to Miss Wilson, and she never responds.
Okay.
So,
Thank you, sir. Okay, so we do have several motions here, but I'm gonna go ahead and set the record straight with regard to some of the procedural history and parameters, and I'll go ahead and entertain brief arguments. On this matter, I do note that first and foremost, this case is sealed pursuant to NRS 125.110, therefore it is limited solely to the parties in this matter, and their counsel, of course. Court notes that when I speak, please do not interrupt. If you want to speak, you'll be given a chance. Do not interrupt one another. There will be plenty of time for both parties to represent their cases in this matter. There being that, the court's going to go ahead and go forward to find that we are here today for several motions. I'm going to give some preliminary background information on this matter, some findings and some background information. This court is very aware of the background of this case. Court finds that petitioner and respondent had one minor child together, born in 2005, who's still in high school, I believe. This is a post-divorce child custody matter. The parties were divorced by stipulated decree of divorce entered on September 27, 2019. Child custody was bifurcated. After an evidentiary hearing on child custody, the court awarded Ms. hereinafter known as legal and primary physical custody, as well as attorney's fees in its decision and order that was dated December 19, 2020. In that decision and order, the district court ordered that defendant, Mr. T. Matthew Phillips herein, shall enroll with the trained reunification therapist in Clark County for assistance in reuniting with the child within 60 days after this order is filed. Defendant may call the child on Wednesdays and Sundays at 6:30 p.m., and the child may freely call the defendant. This is pursuant to the decision and order that was filed and entered on December 19, 2020. The respondent herein, Mr. T. Matthew Phillips, appealed the decision and order to the Supreme Court of the State of Nevada. On April 29, 2022, the Supreme Court of the State of Nevada affirmed the decision and order in its entirety. On June 17, 2022, the Supreme Court of the State of Nevada denied Mr. Todd's petition for rehearing. Mr. Todd filed a petition for writ of certiorari to the U.S. Supreme Court, which was denied on November 21, 2022 on case number 22-5622. Remitter was issued from the Supreme Court of the State of Nevada to the 8th Judicial District Court on December 15, 2022. Therefore, the court does find that this is the court of proper jurisdiction. There are no pending appeals with the Supreme Court nor with the State of Nevada Supreme Court, and the decision and order dated December 19, 2020 is the rule of law. It has been affirmed by the Supreme Court, the highest court in our state. Furthermore, on this January 3, 2023, Mr. Respondent, Mr. Phillips, filed a motion for an order to show cause to eject third-party interloper from service list. Hearing was set for April 4. On January 31, 2023, Respondent, Mr. Phillips, filed for a motion for declaratory relief and modification of custody and child support. Hearing was initially set for April 20, 2023. On February 8, 2023, respondent herein, Mr. Phillips, filed a motion to strike a material scandalous matter, which hearing was initially set for May 2, 2023. On February 14, 2023, respondent Mr. Phillips filed respondent's motion to vacate void custody order, which hearing was initially set for April 27, 2023. On April 19, respondent Mr. Phillips filed a motion to correct a clerical mistake, which hearing was set for August 15, 2023 at 10 a.m. Pursuant to the 8th Judicial District Court Rule 1.10, the procedure in districts courts shall secure proper and efficient administration of the business and affairs of the court to promote and facilitate the administration of justice. Therefore, pursuant to EDCR 1.10, the court hereby consolidated these aforementioned 5 respondent motion hearings: motion for an order to show cause to eject third-party interloper, motion for declaratory relief, motion for custody and child support, motion to strike a material and scandalous matter, and motion to vacate void custody order, and motion to correct a clerical mistake, to one consolidated motion hearing to be heard on this day, August 15, 2023 at 10 a.m. Therefore, that being said, we are here to hear 5 motions. The rule of court has been affirmed, December 19, 2020 matter. Going on to each of these motions, if there's been no resolution herein, I will stand and rule on the papers and pleadings herein. As to the first motion, defendant's motion for an order to show cause to eject third-party interloper from service list, the court has reviewed Mr. Phillips's motion, as well as the limited opposition filed by Ms. The court finds first and foremost that pursuant to EDCR 5.503, every motion, opposition, counter motion, and reply shall include points and authorities supporting every position asserted and an affidavit supporting all factual averments. Points and authorities lacking citation to relevant legal authority or consisting of bare citations to statutes, rules, or case authority do not comply with this rule. The absence or deficiency of points and authorities may be construed as an admission that the filing is not meritorious or as cause for denial of all positions not supported. The court finds that respondent's motion contains no points and authorities. Respondent has cited no legal authorities in support of his motion. Respondent's failure to include points and authorities in support of his request for relief may be construed by this court as an admission that the filing is not meritorious or as cause for denial of all positions not supported. Furthermore, EDCR 5.509 requires that a motion seeking an order to show cause for contempt must be accompanied by a detailed affidavit complying with NRS 220302 that identifies the specific provisions, pages, lines, and existing orders alleged to have been violated, the acts or commissions constituting the alleged violation, any harm suffered anticipated, and the need for a contempt ruling, which must be filed and served on any motion. The court finds that respondent failed to comply with EDCR 5.509 and that he failed to submit a detailed affidavit complying with NRS 220302, identifying the specific provisions, pages, and lines of the existing order alleged to have been violated, the acts or omissions constituting the alleged violation, any harm suffered or anticipated, and the need for the contempt ruling. Therefore, the court finds and concludes that respondent's request for an order to show cause is denied. Opposition. The court finds that respondent's meritless, baseless motion is saved by the petitioner's limited opposition, which was filed on January 18, 2023, which did set forth the requisite points and authorities for this court to grant relief. The court grants the relief requested in petitioner's limited opposition, wherein the court finds, orders, adjudges, and decrees that this case is already sealed pursuant to NRS 125.080 and 125.110. Furthermore, pursuant to EDCR 5.212, subsection A, this court has the legal authority to make trials and hearings private. Further, upon demand by either party, all persons, with limited exception to those delineated in NRS 128.080 A through F, shall be excluded from this courtroom unless the court determines that the interest of justice or the best interest of the child would so be served. Therefore, pursuant to NRS 125.080, 125.110, EDCR 5.212, the court hereby emphasizes and reaffirms that this case is sealed and any and all third parties, including Mr. Falcone, our Nevada judges, its affiliates, agents, assigns, and any and all third-party interlopers or third parties, not including the parties herein and their counsel, are hereby excluded from these proceedings, service lists, and all aspects, any and all aspects of this case.
Alex here. Apparently, Todd Phillips filed something to exclude me and our Nevada judges. I actually had no idea about this until just now as I got this video. So he probably didn't serve it on us, and it wouldn't have really mattered because the statute that he relied upon to do this was constitutional at the time. And as you guys know, both because of the decision that struck down the statute and also because of the fact that I have the video in my possession right now, that law no longer has any effect. So it is weird that this happened because you don't really have to do something like this to use that law. You know, back in the day, you could just close the court just by telling the judge verbally. So for some reason, it looks like Todd went above and beyond and filed something, and it looks like he got what he wanted. But in the end, it didn't matter because we have access to these proceedings now.
The court further finds that in the event that any third-party names appear on the e-service list, it is incumbent on the parties herein to deselect the names of the third parties from the e-service list so as to ensure that the documents that they are filing are only served upon the parties and litigants herein. That's my first ruling with regard to the sealing of this case. I'm going to move on to the next part of the matter with regard to the first motion. Do you have any questions? I'm not entertaining arguments, just questions regarding the first ruling. Your motion was granted, sir, based upon the information that was there. This case is sealed. There will be no third parties. Mr. Falcone or Nevada judges or any other people that are trying to get involved in this case are hereby excluded from being on the service list.
Alex here, just for the purpose of avoiding confusion, this judge is now in compliance with the First Amendment and the Falcone decision, and our access to the case has been restored, and we are once again back on the service list.
Thank you.
You're welcome. Okay, moving on to the rest. Sorry, Ms. Wilson, did you have any questions regarding that ruling? If not, I'm prepared to move on.
No questions, Your Honor.
Okay, thank you. Again, going back to the defendant's motion for an order to show cause to eject third-party interloper from service list, the court also notes that the respondent herein also filed, in response to petitioner's limited opposition, which was filed on January 18, 2023, respondent Mr. Phillips also filed a motion to strike the immaterial and scandalous material from petitioner's opposition pursuant to NRCP 12F. Therefore, the court's going to consolidate those as one document. After having reviewed the respondent's arguments in his motion to strike immaterial scandalous matter from petitioner's limited opposition, the court, and after having reviewed petitioner's limited opposition filed on January 18, 2023, the court hereby strikes the remainder of respondent's motion concerning the quote-unquote Shannon R. Wilson hoax and any reference to respondent's alleged threats to shoot up, quote-unquote, to shoot up his son's school, end quote, pursuant to NRCP 12F, as well as all pages 6 through 11 of respondent's February 6, 2023 motion to strike immaterial and scandalous matter. Pursuant to NRCP 12F, the court may strike from the pleadings any insufficient defense, any redundant, immaterial, impertinent, or scandalous material, and the court may do so on its own motion. The court finds that the language in page 4 of respondent's motion regarding what respondent dubs the Shannon R. Wilson hoax and any reference to any alleged threats to quote-unquote shoot up his son's school, as well as any language in pages 6 through 11 of respondent's 2/6/23 motion to strike immaterial and scandalous matter are immaterial, redundant, and scandalous matter that do not have any probative value in this court's decision to enforce NRS 125.080 and pertinent statutes to ensure that this case is sealed. In its decision and order dated December 19, 2020, the court rendered very specific findings of fact to support its decision and order, granting sole legal custody and primary physical custody, subject to a very specific reunification process that respondent must comply with. The court's findings of fact, conclusions of law, decision, and order were affirmed in its entirety by the Supreme Court of the State of Nevada, with the U.S. Supreme Court denying respondent a writ of certiorari. Therefore, the court finds that December 19, 2022 findings, decision, and order will not be disturbed or reconsidered by this court. Therefore, respondent's arguments on page 4 of his motion shall be stricken in its entirety pursuant to NRCP 12F1 as immaterial, impertinent, redundant, and scandalous, and any and all reference to a Shannon R. Wilson hoax, quote-unquote, or any and all reference to respondent's alleged threats to, quote-unquote, shoot up his son's school, end quote, or any repercussions thereof regarding any third parties not involved in this action, are hereby stricken from the record as immaterial, redundant, and impertinent, scandalous material pursuant to NRCP 12F. The final matter on the first motion is the petitioner's request for attorney's fees, which are granted. I will be deferring the attorney's fees to the end as I make my decision rendering attorney's fees, but for purposes of the first set of motions and the opposition thereto that was filed on January 18, 2023, the court is granting the attorney's fees pursuant to NRS 18010 and EDCR. The court will address all the attorney's fees at the very end of this matter, focusing first on the substance of each of these motions. That takes care of the first motion. I'm ready to proceed to the second motion unless you have, again, I'm not entertaining arguments, but if you have any questions regarding that second motion or clarity on with regard to this court's orders. Ms. Wilson, as the petitioner.
No questions, Your Honor.
Okay. Mr. Phillips, any questions regarding the clarity of the order?
No, thank you.
Thank you, Mr. Phillips. Okay, moving on to the second set of motions, which is respondent's motion to strike. I'm sorry, I apologize. The second set of motions is the declaratory motion. The court is addressing Mr. Phillips' respondent's motion for declaratory relief and modification of child custody and child support, as well as the plaintiff's opposition to defendant's motion for declaratory relief and for attorney's fees thereto. Pursuant to EDCR 5.503, every motion, opposition, counter motion, and reply shall include points and authorities supporting each position asserted in an affidavit supporting all factual averments. Points and authorities lacking citation to relevant authority or consisting of bare citations to statutes, rules, case authority do not comply with this rule. The absence or deficiency of points and authorities may be construed as an admission that the filing is not meritorious or as cause for denial of all positions not supported. The court finds that respondent's motion contains no points and authorities. Respondent has cited no legal authorities in support of his motion. Respondent's failure to include points and authorities in support of his request for relief may be construed as an admission that the filing is not meritorious or as cause for denial of all positions not supported. Respondent's motion for declaratory relief is essentially a motion for reconsideration on matters that have already been adjudicated by the district court, memorialized in the December 19, 2020 decision and order, and affirmed in its entirety by the Nevada Supreme Court, with a writ of certiorari denied by the U.S. Supreme Court. Respondent erroneously argues that the district court terminated his parental rights, which is frivolous, baseless, and wholly erroneous. Respondent's arguments are essentially the same arguments he has made in this case and in his appeal to the Nevada Supreme Court. As noted herein, the Nevada Supreme Court has already rejected respondent's arguments, including his argument regarding alleged termination of parental rights. The Supreme Court affirmed the December 19, 2020 district court decision order in its entirety. The Supreme Court further denied respondent's request for rehearing. Finally, the U.S. Supreme Court denied respondent's request for writ of certiorari. Therefore, the decision and order of the district court dated December 19, granting Ms. sole legal primary physical custody stands subject to the respondent's reunification process that he must comply with, as well as limited visitation with his son pursuant to the order that stands. Respondent's parental rights, the court finds, respondent's parental rights have not been terminated. Therefore, respondent's arguments concerning any due process or termination of parental rights are baseless. The state absolutely has the right to make custodial orders in the best interest of the child pursuant to Rico v. Rodriguez, 121 Nevada 695. Respondent's custodial rights to his child are clearly delineated in the decision and order. It is up to respondent to exercise his parental rights by following through on the reunification therapy process clearly delineated in the decision and order, which was found to be in the best interest of the child for the protection of the child due to the court's finding of clear and convincing evidence of domestic violence that both child and subjected to at the hands of the respondent. These orders are in the best interest of the child. They're grounded in law. They have been affirmed by the state, the highest state of our court. Therefore, there is no legal basis for this court to modify, set aside, or declare the decision and order that has already been affirmed by the highest state of this court. Therefore, the court denies respondent's motion for declaratory relief. Moving on to the same motion, there's a motion for modification of custody. The court does find that pursuant to NRS 125C00451, this court has jurisdiction to modify custody at any time during the pendency of the action, at the final hearing, or at any time thereafter during the minority of the child. A modification for a primary physical custodial arrangement, which is what we have in this case, is appropriate when, 1, there's been a substantial change in circumstances affecting the welfare of the child, and 2, the modification serves the child's best interest, pursuant to Ellis v. Carlucci. The moving party bears the burden of satisfying both prongs. The court finds that the moving party in this case has not satisfied either prong, as has failed to show generally any substantial change in circumstances since the most recent custodial order, or how this substantial change in circumstances has affected the welfare of the child, or that modification would serve the best interest of the child. Our respondent has failed to establish either of these prongs. Therefore, respondent's motion to modify custody is hereby denied. Modification of child support. EDCR 5.507 states that unless otherwise ordered by the court or otherwise required by another rule or statute, a general financial disclosure form, also known as an FDF, must be filed in support of any motion or counter motion that includes a request to establish or modify child support. A GFDF must be filed in support of the document, and it must be filed within 3 days of the filing of the motion. The court does find that respondent, Mr. Phillips, filed a motion for declaratory relief, modification of custody, and child support on January 31, 2023. Respondent, Mr. Phillips, failed to file a GFDF within 3 days of filing his motion to modify child support. Therefore, pursuant to EDCR 5.507, subsection G, the court may construe respondent's motion as not, the court may construe respondent's motion not supported by a timely, complete, accurate FDF as admitting that the positions asserted are not meritorious and cause for entry of orders adverse to those positions as a basis for imposing sanctions. Subsection G reads in its entirety for the record. EDCR 5.507, subsection G reads, the court may construe any motion, opposition, or counter motion not supported by a timely, complete, and accurate financial disclosure form as admitting that the positions asserted are not meritorious and a cause for entry of orders adverse to those positions and as a basis for imposing sanctions. The court finds that respondent's failure to file his FDF within 3 days of the filing of his motion, pursuant to the requirements set forth in EDCR 5.507A, as well as 5.507D, as well as 5.507G, shall be construed by this court as grounds that the motion is not meritorious and adverse, and as a basis for actually this court imposing sanctions. The court finds and concludes that respondent violated EDCR 5.507 by failing to file a timely, complete, and accurate FDF with a motion to modify. The court therefore denies respondent's motion to modify child support as not meritorious. The court further finds that case number R20215472R is the child support case that is handling any changes in child support must be handled through that office and through case number R20215472R. The court grants petitioner's request for attorney's fees, which shall be discussed at the end of this motion. Again, this is pursuant to NRS 18010, as well as the pertinent EDCRs, in that respondent, the petitioner herein is the prevailing party on all counts and on all relief sought. I'll address attorney's fees at the end. Before I move on to the next one, are there any questions? That is my ruling with regard to the second set of motions, which was the motion for declaratory relief, modification of custody, modification of child support. I'm not entertaining arguments, only questions regarding my rulings. I'm sorry, Ms. Wilson.
No questions, Your Honor. Thank you.
Thank you. Mr. Phillips.
May I state for the record what I believe is a factual correction?
Absolutely, sir.
There has never been any allegations of harm to the minor child. The petitioner claims that I threatened to kill her and beat her up every day for 20 years, and we don't need to get in the nitty-gritty. There are no allegations of harm as against the minor child. There's no allegations of child abuse, no child neglect, no child endangerment, no child abandonment, no CPS reports, no substantiated CPS reports. There is no documented harm, no documented history of any harm or even any allegation of harm to the minor child. It's just the verbal allegations from the petitioner's mouth, standing alone, and she has every motive to falsify.
Okay.
But I'll leave it there, and thank you for listening.
You're welcome. Thank you, sir. So noted. And again, I stand by the decisions and the facts and the factual findings set forth in the December 19, 2020 decision.
And
So
I just-
I don't believe I said that there was harm, those words, harm to the child. I said that I stand by the court's findings, which were that that's in the best interest of the child for his relationship with you to be contingent on a reunification process that was set forth very clearly. Also, you also do have time with your son to be able to call on very specific days of the week. I do have that written here. And I'm not upsetting or changing those findings. I don't find that there's any basis to change that right now, sir.
Thank you.
Okay? But thank you. I do know what you just said. Thank you, sir. Okay. So moving on to the next matter, which is respondent's motion to vacate the void custody order. The court further finds that, again, pursuant to, in the interest of not having to repeat myself, I cited EDCR 5.503, which is every motion, counter motion, reply must set forth points and authorities supporting every position asserted and factual averments, points and authorities lacking citation to relevant authority, consisting of bare citations to rules, statutes, or case authority do not comply with this rule. The absence or deficiency of points and authorities may be construed as an admission that the filing is not meritorious or as cause for denial therein. The court further finds that in respondent's motion to vacate a void custody order, respondent failed to set forth any legal basis to set aside the decision and order dated December 19, 2020, as set forth herein and incorporated herein in this court's findings and orders. As to the prior motions, respondent's arguments are essentially the same arguments he has made in this case and in his appeal to the Nevada Supreme Court. As noted herein, the Nevada Supreme Court has already rejected respondent's arguments. The Nevada Supreme Court affirmed the December 19, 2020 District Court decision in its order in its entirety, having considered the procedural history in that case concerning the various judicial departments. The Supreme Court further denied respondent's request for rehearing. Finally, the U.S. Supreme Court denied respondent's request for writ of certiorari. Therefore, the decision and order of the District Court dated December 19, 2020 stands, and the court therefore denies the respondent's motion to vacate the void custody order. I don't believe there was an opposition or any attorney's fees sought in that one. Therefore, no attorney's fees are granted on the third motion. Any questions regarding that ruling? I'm not entertaining arguments, but any questions regarding that ruling? Ms. Wilson, I did not see an opposition or request for fees on that third motion.
No opposition was filed. No fees are requested. No questions, Your Honor. Thank you.
Thank you. Okay, so no fees will be awarded on that one. Mr. Phillips.
I have a question.
Absolutely.
Are you allowing argument on this motion? You said you just wanted questions. Are you forbidding us to argue the motion?
Well, I've already read everything, that's why I asked if there were any updates or any resolution, because I'm prepared to rule, the court is allowed, actually, the court was prepared to rule on the moving papers without hearing, but I wanted to be able to see the parties today in the interest of full disclosure.
And
So,
I-
if you have any additional arguments, I have everything here. You
Yeah.
have fully briefed this matter, sir, by providing
Yeah.
me with a plethora of motions to review, as
Yeah.
well as the history of this case, so I'm not willing to entertain a regurgitation of arguments that are already in the documents that I've
Okay.
reviewed. But however, if you do have something that you would like to note that you did not
Yes.
put, then absolutely, sir.
Yes, I do have a new argument.
Okay.
I think Your Honor, respectfully, is maybe being a little bit persnickety. You know, I understand that nowhere in my documents do I say points and authorities. I know a lot of attorneys do that. I've been practicing law for 31 years. Grounds for relief? I think the grounds for relief is substantially similar to saying points and authorities. I clearly cite to Rule 60B and Rule 60B4. I cite the leading cases. I have Santosky versus Kramer on the issue of explaining how a void order, an order like this can be voided out. I cited the case of Christie versus City of El Centro. You said I didn't have any points and authorities, but I do. It says orders entered after disqualifying acts arose is properly deemed void. Your Honor has subject matter jurisdiction, the authority to void out this case based on the citations that I provided to the court. This is not just bare bones allegations and naked conclusions, but rather we cite to Christie versus City of El Centro. We also cite the Nevada case Hoff versus 8th Judicial District. And clearly Ochoa and I were adversarial, not just because I was suing him, but also I had busted Ochoa out on campaign violations. He was fined by Nevada Secretary of State. And on the day he took away my child, I had just busted him out with the Secretary of State, and I was adversarial in court. And clearly these would be grounds to void it out. I know I'm going a little bit into the argument, but I just want...
And these are in your arguments, sir, and I
Yes,
have read
and
them, so
so-
thank you, sir.
There are points and authorities,
Okay.
despite the fact, and there's the ancient doctrine of form over substance. You are correct. I don't use the words points and authorities, but I think legal grounds is substantially similar. I hope your Honor will consider that. So
Okay.
that's what I wish to say.
Thank you, Mr. Phillips. Ms. Wilson, would you like to respond? Since I gave Mr. Phillips the opportunity to address the court.
I don't have any response, Your Honor. Thank you.
Okay. And the court, having reviewed the papers and pleadings herein and reviewed the cases that were cited by the respondent herein, the court stands by its order that this matter has been affirmed by the Nevada State Supreme Court, the highest state. All of these matters were addressed before the Supreme Court. The Supreme Court has denied the petition for rehearing. The U.S. Supreme Court has denied the petition for writ of certiorari, and therefore the decision and order rendered by this court, by the 8th Judicial District Court of Nevada on December 19, 2020, those decisions stand. I have one more motion here. I believe this is the one where I will need some information from the folks. That's defendant's motion to clarify a clerical mistake. I believe that's the last one. This one, I have reviewed the document, and I really am going to look to you because I was not the judge in this matter. I do see a couple of readings of this. I understand that Mr. Phillips is requesting that I'm specifically looking at the language on page 43, line 23. It says, however, at the hearing for the protective order, plaintiff learned that defendant made phone calls to the child's school and threatened, ... I'm not trying to rehash testimony. I just want a simple question. If there is a stipulation to this, if plaintiff and defendant's names were in fact transposed, I can go ahead and take this up to the Honorable Judge Ochoa. But at this point, I'm not going to reopen a case and rehear arguments or rehear testimony. My question is very limited. Is should it be changed to read, however, at the hearing for the protective order, defendant learned of plaintiff's allegation that defendant made phone calls to the child's school and threatened. I'm specifically, I apologize if I'm reading them both out of context. I'm taking this directly from Mr. Phillips's motion. I understand that it first said, however, at the hearing for the protective order, plaintiff learned that defendant made phone calls to the child's school. My reading of that does align with my reading of the rest of the testimony, as well as the papers and pleadings, that plaintiff learned that defendant allegedly made phone calls to the child's school. And so at this point, I really am gonna ask the plaintiff, or Ms. Wilson, because this is regarding your client, is it true? Is it that at the hearing on the protective order, did plaintiff learn that defendant made phone calls to the child's school? If you're able to respond, and if you're not, then, that's fine, I'm not trying to rehash a case.
That is correct. The plaintiff learned that information at the hearing on the protective order.
Okay. So, and at this point, I'm not going to rehash anything. I know that Mr. Phillips wanted to change a couple other items, but at this point, this knowledge, the source of knowledge stays with the plaintiff. So, Ms. Phillips, I understand that your counsel is saying that at the hearing for the protective order, is it accurate that plaintiff, that you learned that defendant, as the word state, made phone calls to the child's school?
When?
Do you understand the question? Can you repeat the question?
Sure, I just want to make sure that tell me if this is an accurate statement. This is what's listed in the decision and order. It says, at the hearing for the protective order, plaintiff learned that defendant made phone calls to the child's school and threatened ...
Sounds accurate.
Is accurate?
Yes.
Okay.
Yes,
So
ma'am.
at this point, I'm not inclined to change the orders of the court to add more language in it. My only question was whether or not that was plaintiff that learned that defendant made phone calls. So at this point, I'm going to go ahead and take her testimony and find that her testimony is credible. Mr. Phillips, I recognize that you're asking me to read into it and add more language. I'll go ahead and hear your argument, but I did receive her testimony already. But go ahead, sir.
Well, first of all, I'd like to say this motion is unopposed. And I notice Your Honor was very persnickety with the rules, I think almost unfairly to
Now,
me.
counsel, I'm going to have, sir, you've called this court persnickety not once but twice.
Yes.
And I'm going to take issue with that because I mind you that, you
Okay.
know, you calling the court language can be actually construed as contempt of court if you're standing before this court and you're calling me names. I have at
don't
all
think
times
it's
been
name calling, I'm
utmost
sorry.
respectful to the parties, and I will
Okay.
not tolerate any name calling in my courtroom.
Fair enough, I understand. The point is that I don't think they get to be heard today. And
That's my call, not
I-
yours, sir.
I understand that, but I just wish to say that according to the rules, if they don't file an opposition, the court is entitled to presume the meritoriousness of my motion because it's unopposed. What I'd like to say here is if,
Let
you know-
me move on to the next point before you move on to that
Okay,
one.
yes.
The rules do allow the court may, it's not shall, but
Mhm.
it's may grant a motion if it's unopposed on the merits though. In this case, I don't find that the merits have value. That's why I wanted to have this hearing today to get clarification from the only person that can speak to what the plaintiff learned is the plaintiff, not you. It says at the hearing for the protective order, the plaintiff learned that defendant made phone calls to the child's school. I have no reason to question or uproot the decision rendered by Judge Ochoa on his decision and order, especially if it was already affirmed by the highest court in our state. But I wanted to give you the benefit of the doubt to have this hearing today, sir, to ask the plaintiff if this was in fact correct. If the plaintiff was to tell me today that it should have been plaintiff and not defendant, and vice versa, that she didn't learn that, then I would have been willing to grant your request. But this request had to have me sitting here to take testimony. And based upon the testimony that I've received, I'm going to go ahead and deny your motion and find that the order that was written by the 8th Judicial District Court on December 19, 2020, that was affirmed by the highest court in our Supreme Court, is now hereby affirmed, and your motion is hereby denied, sir. No motion, no opposition or request for fees were sought on there, so no fees will be granted on the
Okay.
fourth motion, sir.
I would just, what I like to say here is if I could just read, and that this is faithfully reproduced from the record. After the parties' final separation, plaintiff, which is the mom, was called by the child's school as she was on her way to pick up the child. When she arrived at the school, she saw police cars everywhere. The
Sir,
school-
what is the purpose of this? I'm not
I just-
entertaining, I'm not
That's-
going to open up the findings, so I don't really need you to read the whole case into the record.
I just
I'm
wanted to,
speaking specifically just to this language here,
yes,
which is plaintiff at the hearing on the protective order. The question is whether plaintiff learned that defendant made phone calls to the child's school. I'm not going into the threats or any of those
right, I
other
understand.
threats.
I understand, I just wanted to, I was about to get to the point where the
Okay.
police asked plaintiff to step aside.
Okay.
The police asked her questions. She was interviewed by the police on the scene. Of course she knew what it was.
Well, that's
I-
speculation. We
okay.
don't know her
Well-
conversation with police. I was a part
Okay.
of that, and I don't think you were either, sir.
Well, yeah, well, okay, you may be right about that. They may have interviewed, well, all right. I don't wish to argue, but I do wish to say that it was I who first learned about the school shooting in court. Shannon Wilson just brought it up out of nowhere that I, supposedly had shot up a school or attempted to shot up a school. I was blindsided by that. There was no prior warning. I was the one who first learned of it in court. And the point is, obviously, at least in my way of thinking, she knew about it because she was interviewed by the police, and she obviously told her attorney who brought it up in court. So I was the one. That is, I think, clearly, I'll file some additional paperwork to correct it. I understand your position. I will say also, I notice Your Honor has said several times that the Nevada Court of Appeals has affirmed and that the U.S. Supreme Court has affirmed. And I think that is a fair and accurate representation. I do wish to add, however, there has never been one time that any Nevada jurist or any federal jurist has ever said your constitutional arguments lack merit. I just wish to put that on the record. It just said that the way I would describe it is that they basically ignored my arguments. But be that as it may, I just wish to add that part. So
Okay.
thank
you very much, sir.
Mm-hmm.
Okay. So at this point, I believe the court has rendered rulings on all of the motions that were pending before this court. Now, all that remains is the motion for attorney's fees. The court notes that the motion for attorney's fees on the first two motions, namely the motion for a third-party interloper and the motion for declaratory relief, motion for attorneys, the opposition and the request for relief and attorney's fees are hereby granted pursuant to Miller versus Wilfong. Attorney's fee awards to pro bono counsel are proper, provided that a legal basis exists and proper factors are applied to support the award. The legal basis for granting attorney's fees for the first two motions herein, in this case, is pursuant to NRS 18010-2B, as well as EDCR 7.30B1 and B3. Pursuant to NRS 18010-2B, the court may award attorney's fees if it finds that respondent's claims were brought or maintained without reasonable ground or to harass petitioner who is the prevailing party in these two motions. The court shall liberally construe the provisions of this paragraph in favor of awarding attorney's fees in all appropriate situations. The court may award attorney's fees and impose sanctions pursuant to Rule 11 of the Nevada Rules of Civil Procedure in all appropriate situations to punish for and deter frivolous or vexatious claims and defenses because such claims and defenses overburden limited judicial resources, hinder the timely resolution of meritorious claims, and increase the cost of engaging in business and providing professional services to the public. Furthermore, pursuant to EDCR 7.60, the court may, after notice and opportunity to be heard, impose upon an attorney or party any and all sanctions which may, under the facts of the case, be reasonable, including imposition of fines, costs, or attorney's fees when an attorney or party without just cause presents to the court a motion or an opposition to a motion which is obviously frivolous, unnecessary, or unwarranted. The court finds pursuant to NRS 18010-2B, EDCR 7.60B1, and EDCR 760B3 that attorney's fees are warranted and that plaintiff and her counsel have had to defend against respondents' arguments which are frivolous, unnecessary, and unwarranted. Furthermore, pursuant to NRS 18010-2, respondent has so multiplied the proceedings in this case as to increase costs unreasonably and vexatiously. The court further finds that these claims were brought or maintained without reasonable grounds or to harass the petitioner, who is the prevailing party in both these motions. Respondent's claims overburden limited judicial resources, hinder timely resolution of meritorious claims, and increase the cost of engaging in business and providing professional services to the public. This is evidenced by the Plaintiff's Exhibit 3, Plaintiff's Exhibit in her opposition thereto to the respondent's motion. Exhibit 3, 4, 5, 6, 7, and 8, demonstrating respondents' vexatious, litigious, harassing allegations and threats. Namely, Exhibit 3, in an email from respondent to petitioner's counsel dated 12/22/2021, the respondent Phillips says to petitioner's counsel, "I'm going to be doing some more slash and burn litigation, the kind which you've grown accustomed to, the kind for which you won't be paid," end quote. Specifically, Exhibit 4, in an email from respondent Phillips to petitioner's counsel dated August 25, 2021, Mr. Phillips says to counsel, "I have a new lawsuit for you. Will you accept service or process? Or maybe we should make this as expensive as possible You've already lost $179,000 in attorney's fees. The court further notes in Exhibit 5, in an email from respondent Mr. Phillips to petitioner's counsel dated 4/16/2019, Mr. Phillips says, dealing with you and your client is impossible, which explains why this litigation and the soon-to-be filed spin-off litigation will last likely 3 or 4 years. Court further notes and finds that Exhibit 6, in an email from respondent Phillips to petitioner's counsel dated March 27, 2019, Mr. Phillips says, expect a flurry of litigation and you'll not be paid a thin dime for any of your work. Court further notes Exhibit 7 references Mr. Phillips' email to petitioner's counsel dated March 14, 2022, wherein Mr. Phillips says, hey Wilson, you're never getting a dime out of me. Keep spinning your wheels. Print this out. Make sure you include this in your next appendix. Put this in your reply brief. I dare you. Further, the court notes that Exhibit 8 references an email from respondent Phillips to petitioner's counsel dated March 21, 2022, wherein Mr. Phillips says, print out this email, take it to court, and start bellyaching about whirlwinds of litigation. The court finds that these exhibits, among others, are offers of proof to establish that respondent is vexatious, vindictive, and resolute on filing frivolous, baseless motions and causes of actions against petitioner, her counsel, and anyone who gets in his way of harassing petitioner and her counsel, including judicial officers who have ruled against respondent. This is further evidenced by respondent's history of filing baseless causes of actions against petitioner, petitioner's counselor, judicial officers that have ruled against respondent, which are all clearly delineated and referenced herein in footnote 5 of page 11 through 12 in petitioner's limited opposition dated January 18, 2023, delineating respondent's litigious nature as evidence in at least 10 causes of actions filed in the 8th Judicial District Court, Nevada Supreme Court, Federal District Court of Nevada. The court hereby incorporates footnote 5, pages 11 through 12 of petitioner's motion dated January 18, 2023 herein. In the interest of time, I can incorporate it or I can read the whole footnote, but I'll just go ahead and incorporate it here in footnote 5, pages 11 through 12. The court finds that respondent's motions are frivolous, baseless, and without merit, and based upon the totality of circumstances, including respondent's history of filing baseless claims against petitioner, her counsel, and any judicial officers, the court finds that respondent filed the instant motions against petitioner with the intent to harass, intimidate, and burden petitioner and this court with baseless, frivolous, and protracted litigation. Therefore, pursuant to NRS 180102B and EDCR 7.60, the court has wide discretion as it pertains to making orders where a party has presented themselves in a manner and presented frivolous, unnecessary filings motions and has unreasonably increased fees and costs in this matter and has failed and or refused to comply with the rules and orders of this court. Therefore, the court finds that pursuant to EDCR 7.60 and NRS 180102, respondent has presented frivolous, unnecessary filings motions, unreasonably increased fees and costs in this matter, and has failed or refused to comply with the rules and orders of this court, and is therefore liable for petitioner's award of attorney's fees and costs in having to defend against respondent's motions 1 and 2 herein, subject to the Brunzel analysis. For the court's record, respondent's motions that I'm referring to is the first motion, which was the defendant's motion for an order to show cause to eject third-party interloper from service list. The limited opposition that the petitioner filed and for request for fees is hereby granted. Any and all fees pertinent to that motion are granted subject to the Brunzel analysis and affidavit. In addition, the defendant's motion for declaratory relief, modification of custody, and child support, the opposition thereto filed by petitioner and attorney's fees sought are hereby granted, subject to, of course, a Brunzel analysis. The other motions did not have oppositions nor were fees sought, although the petitioner was the prevailing party. In those matters, there are no fees that are granted. The court further notes, for the record, that protracted litigation arises when a party files several lawsuits against the same adverse party, asserting a right to recover arising from the same common nucleus of facts, which have already been litigated by the highest court of the state. A vexatious litigant is defined as one who repeatedly files frivolous lawsuits. In order to deter such conduct, the Nevada Supreme Court has allowed for the court to limit such vexatious litigants' right of access to the court, unless that litigant does first demonstrate to the court that the proposed case is not frivolous. This is pursuant to Peck v. Krauser, 295, P3D 586-587, 129, Nevada Advanced Opinion 12, 2013. The Nevada Supreme Court has set forth a 4-step analysis when this court is issuing a vexatious litigant order. And I am noting that the first one is to provide reasonable notice of and an opportunity to oppose a vexatious litigant finding an order. 2, to provide a record in support of such an order. 3, how the litigant's actions constitute vexatious, make a substantive finding as to the frivolous and harassing nature of the litigant's actions, and 4, a litigant's constitutional right to access the court must be protected by making the vexatious litigant order narrowly tailored to the issue at hand, i.e. if the litigant repeatedly asserts the same claim, a restrictive order would be limited to raising that same claim. This is set forth in Jones v. 8th Judicial District Court, 330 Nevada, P3D 475, 130 Nevada Advanced Opinion, 53, 2014. See also Jordan v. State in Department of Motor Vehicles, Public Safety, 121 Nevada 44, 110 P3D 30, 2005. The court notes that while there has not been a motion for a vexatious litigant that was filed before this court, the court is willing to entertain one should either party seek one, because the court does note that there is a record here establishing a vexatious litigant. There is a record here establishing that a constitutional right to access to the court must be narrowly tailored, in that the court's decision and order dated December 19, 2020 has been affirmed and will not be disturbed by this court. And therefore, if there are any further motions that are filed to try to disrupt, set aside, or to clarify the motion that was already upheld by this court, the order that was already upheld by this court will be denying that unless there is new evidence and new grounds. However, the court notes that this matter was already taken to the Nevada Supreme Court and has been affirmed. And so, while I don't have a vexatious litigant motion before me, I do have enough of a record to move forward on one should reasonable notice and an opportunity to be heard and a motion be filed. So I leave that for both parties to be aware of. At this point, my ruling is done. Ms. Wilson, I'm going to ask you to please prepare the order, as well as submit a Brunzell analysis. I do recognize this was a very lengthy order. You can order the JABS tape, but this order will lay to rest several issues that hopefully we will not have to address at another time. At this point, I thank you both. Mr. Phillips, I thank you. It was an honor to have you here before us today. And thank you, Ms. Phillips, or Ms. Thank you for the time. My hope is that we will not have to continue litigating matters that have already been resolved by the court. Thank
May
you.
I be heard?
Thank you, Your Honor.
My ruling, sir.
I just wish to add something I didn't get a chance to say here.
Okay.
And I think it's important. When someone is declared a vexatious litigator, it's generally because there's a violation of the Nevada rules of civil procedure, particularly Rule 11B2 and Rule 11B3. If somebody makes an argument that is not warranted by existing law, or if they state facts that lack evidentiary support.
Sir, I'm
under
aware of
B3.
the rules. At this
And there's-
point,
there's
I
never-
have not rendered that finding, but I am making it very clear
Mhm.
that should this matter come back before me on a
Mhm.
motion for a vexatious litigant, there's enough of a record here, and I'm very familiar with the record of this case because I took several hours to read the history of this case, and so I am open to addressing it at that time. But today, I just kind of put everyone on notice.
There's
Yeah.
never been a Rule 11 violation
Okay, sir.
filed by them.
So then at this
And-
point, everything is speculative, right?
And can I make one more thing? I want to ask Your Honor for a temporary order here. This is what I started out to say, what reason I came here, and the reason I wanted you to hear the matter, is I haven't heard my son's voice in 5 years. No one in my family has heard his voice in 5 years. I wanted to propose an order where I could pick him up on Friday and then drop him off at school on Tuesday so I wouldn't have to see the petitioner. Now, I know Your Honor can't change the ruling of primary custody, but I'm hoping Your Honor would have the discretion to make the order consistent with the Roe finding. The Roe finding that just happened from the Court of Appeals says that if somebody gets awarded primary custody, that the timeshares have to be consistent. I have no timeshares and no contact of any kind whatsoever. For 5 years, I've been no phone calls. He's never answered the phone. I've had a right to call, but she has completely cut me off from the minor child. I would ask Your Honor respectfully if I could see my son, pursuant to the Roe decision, which says that primary sole custody, you can't cut off the outlier parent completely. She would have, again, we can't change Ochoa's ruling, but I believe you have the authority and the subject matter jurisdiction today to make her award of primary custody fit consistent with the Roe ruling. Because Roe says that when a parent like myself, I've never been found unfit, I've never alleged to be unfit. And therefore, if I could pick up the minor child, and let's say he didn't want to come with me, I would look him in the eye and tell him, son, I love you, call your mother, she can come pick you up, and I could try again the following week. But he's in less than 3 months, he's going to be a man. He's going to be 18. This is my last opportunity to be a father to him. And
Okay, sir, let me hear from her counsel,
Okay.
okay? Thank you, sir. Ms. Wilson, I recognize that this is an oral motion that he's making. Not too far off from the motion that you did file a motion to modify custody, so you did file a motion to modify custody.
based on Roe.
Okay, go ahead, Ms. Wilson.
In Roe, Your Honor, 7 years after the parties' divorce, Ms. Roe filed a motion to modify custody of the minor child, who was at the time 11. At that time, the parties shared joint physical and legal custody of the child. Maggie, the mom, sought primary physical custody and asked the district court to enter orders for therapy for the minor child and a brief focused assessment to determine the likely cause of the change in demeanor of the child. Dad filed a counter motion for primary physical custody, and the district court granted the motion for therapy, a brief focused assessment, and set a hearing for the parties' motions to modify custody. The therapist then recommended that the district court enter a behavior order for both parents and maintain week-on, week-off parenting time schedule. Right? Herein lies the significant difference, I think. The district court adopted that recommendation and entered an order for the parties to maintain joint legal and joint physical custody before the status check. This is where the cases diverge, right? Mr. Phillips has not once followed this court's orders for therapy. There is no change of circumstance to warrant the temporary order that Mr. Phillips is seeking. And therefore, as this court has said repeatedly today, all prior orders must stand. Thank you.
Thank you, counsel. Okay. Having heard the arguments that are respectfully being brought before this court and the arguments in the oral motion, sir, while I respect your request, as I've already delineated herein, you filed a motion to modify. You're essentially asking to modify, even if it's to modify the visitation. You're seeking to modify. A motion to modify has to be brought before me. You have to present a substantial change in circumstances affecting the welfare of the child, and the best interest of the child is the paramount concern. The court, in its decision and order, rendered some very specific findings around your contact with your child to be through a reunification therapist, a reunification process. It was incumbent on you, sir, to find a reunification therapist so that your son and you could reunite in a place, in a therapeutic setting. This was set forth in place because the best interest of the child, considering all of the factors set forth in the decision and order. You were also granted time to contact your son via phone. So there's some very limited, very, very specific orders that were set forth in place so that you can have a bond, reunify, and heal with your son. Have you done that, sir? Have you?
No, I
yes?
haven't.
Okay, that's
and
all I
wish
needed to
explain
know.
Why.
And that's all I needed to know, because, sir,
because
you have an order that sets forth the steps that you. This is on you, sir. It's up to you to contact the reunification therapist so that you can start having a relationship with your son.
Well, let me say
So,
here,
at this
they
point,
want me to go to Donna's house. I don't want my minor son to have to go by the armed guards and metal detectors. It's like a military presence in here. My son should. It's like going and visiting someone in prison. I have never been arrested, indicted. There's no CPS reports. There's nothing against me. There is no documented evidence. I'm an officer of the
sir,
court.
that is your choice. But however, I
Okay.
remind you to read the decision and order.
Is it
sets
required
forth.
by law?
Yes, it is. You are ordered to contact
But
the
not by law.
reunification.
The law doesn't require.
Well, if you want, it's up to you if you want to visit with your son.
Okay.
Your visits with your son are contingent on you following the instructions.
Yes,
Okay.
but I
The
just
court
wish-
is done. My ruling has been rendered. Thank you very much, sir. Have a great day.